Hi, I'm Gary DeWitt. I own DeWitt Law Firm where I do estate planning and probate and do it well. What happens when you don't have a will? If you have questions what we're talking about today, if you have estate planning questions, if you have probate questions, if you have questions in general, or just want to talk, go to planwithgary.com. If you don't have a will, your final estate is subject to what is called administration. It is much like probate, only who gets how much has already been determined by state law. Without a will, the state, not you, decides who gets how much. When is decided by whether or not your family quarrels. But it will take at least 8 months to get done, and it will cost the family at least 6% of the estate to get it done. Every step of the administration process will happen under the scrutiny of a judge. A judge must approve every decision. Even if one family member objects, the entire process could take years and lose the estate a lot of money. Your spouse only gets a portion of your estate. In Arkansas, your spouse gets 1/3 of your personal property. That is, whatever isn't real estate. Your children split the other 2/3 between them evenly. If they can't agree on what property each one wants, then the judge may order it all sold and the money split between the children. Your spouse gets an interest in the real estate called a fractional life estate. This means she can live there and collect rents and royalties for the remainder of her life. However, your spouse can't sell the property without the permission of the children. And then, your spouse will only get her portion of the proceeds from the sale. The children then get the property as tenants in common after your spouse passes. If you have questions about what we're talking about today, if you have estate planning questions, if you have probate questions, if you have questions in general, go to planwithgary.com. You can also call or text 479-717-6300. Thank you for watching today.